Good afternoon. I think we're going to go ahead and get started. I'm going to share my screen. If you have any difficulties seeing the slides or hearing me, please just drop that into the chat and we'll try and fix any issues that may arise. And if one of my colleagues could let me know if you guys can see the slides.
We can see your slides.
Okay, great. So we're going to go ahead and get started. This is Contracts, Procurement, and FOIA, the third in our FOIA summer series. My name is Brandon Lewis. I'm the trial attorney here at the Office of Open Government, which is one of two offices within the Board of Ethics and Government Accountability. The staff here at OOG is led by Director Nikel Allen. Louis Neal is our Chief Counsel. I'm joined today by my colleagues Anthony Skirbo, Attorney Advisor, Joan Lelma, Attorney Advisor, our Paralegal Specialist, Kimberly Brown, and our IT Specialist, Kevin Brown. And the agenda for what we're going to discuss today is going to focus on these 4 points. So first, we're going to discuss just kind of some foundations of DC FOIA, as well as procurement laws here in the district. Then we'll discuss procurement records. We'll address proactive disclosure and FOIA requests. And then we'll finish by discussing the most applicable exemptions in the procurement space, as well as a little bit on redactions. Okay, foundations of DC FOIA and procurement. So, as you already know, the DC Freedom of Information Act, it is the public policy of the District of Columbia that all persons are entitled to full and complete information regarding the affairs of government and the official acts of those who represent them. So DC FOIA provides the public with the right to access government records and is designed to promote transparency and accountability across the district government. And I've just included a couple of slides with the relevant sections from the DC Official Code that deal with the Freedom of Information Act, as well as the relevant regulations from the DC municipal regulations that are known as the DCMR. And I will say at this point, since we usually get this question, these slides will be available. They'll be on our website under the training section, so you can reference any of the laws and regulations, and there'll also be several links for more information. So with regards to procurement law in the district, DC contracting and procurement is governed primarily by DC Official Code Title II, which deals with government administration. And then there are a number of chapters that are specifically centered around procurement. So sources for locating relevant procurement laws and regulations include Title II of the DC Official Code, the website of the Office of Contracting and Procurement, and then additionally, OCP has a separate part of its website that has regulations and manuals. So all of these would be resources to use if you have a question regarding a procurement issue in the district. Next, we're going to discuss procurement records. But we're going to start by talking about public records in general. So the term public record is defined in the DC Code, and public records include all books, papers, maps, photographs, cards, tapes, recordings, vote data, or other documentary materials, regardless of physical form or characteristics, that are prepared, owned, used, in the possession of, or retained by a public body. Public records also include information that's stored in an electronic format. And I think most of you probably know at this point, but just in case you didn't, electronic format includes text messages and some applications. And here I've included a link to a relevant advisory opinion that the director published specifically on the issue of text messages and their applicability of DC FOIA to text messages. I would also note that public records includes the records of some contractors. So it includes any record that is produced or collected pursuant to a contract with a private contractor to perform a public function. Now getting specifically into procurement records such as requests for proposals, commonly known as RFPs, bid documents, award notices, and contract terms are generally considered public records when prepared, used, or retained by the agency as part of the procurement process, and they must be disclosed under DC FOIA unless they meet one of the exemptions that's set forth in DC Official Code 2-534. So this would include pre-award records, records of the award itself, and then any post-award materials. Common procurement records include solicitations, vendor proposals and bids, valuation records, contract award documents, and invoices and purchase orders. Then we're going to get into what exactly these kind of 5 categories of procurement records might look like. And so solicitations are documents that are issued to vendors announcing a procurement opportunity and outlining the requirements, evaluation criteria, and submission instructions. And examples of these could include requests for proposals, requests for quotations, or requests for task order proposals. Also, I would mention that if at any point you have questions, feel free to drop those into the chat. And if they're able to, my colleagues will answer them. Or if not, you can also ask your question at the end. So next, vendor proposals and bids. These are vendor submissions responding to solicitations, including technical proposals, price proposals, past performance information. And these documents often contain commercial or financial information. Valuation records. These are internal agency records that are used to assess proposals, and they may include scoring sheets, technical evaluation reports, source selection memos. And I've also noted at the bottom that portions of these types of documents may fall under the DC FOIA exemption for interagency or intra-agency communications, DC Official Code 2-534, and we're going to discuss that in a little bit more detail later. Okay, contract award documents or also contract amendments and modifications. So contract award documents are documents announcing the selected vendor and the terms of the award. Contract amendments and modifications are basically exactly what they sound like. They're formal changes made to the contract terms, scope, pricing, or duration. The Office of Contracting and Procurement is required to post contract awards greater than $100,000. And these can be found on OCP's transparency portal, which I provided a link for if you want to check that out. Invoices and purchase orders. These are documents that include billing, payments, and purchase order transactions. And the OCP portal also has that information as well. And here's just a list of, by no means exhaustive, but just some example of internal procurement documents. These might include agency evaluations, scoring sheets, as I had mentioned before, technical reviews, source selection memos, and communications with vendors such as emails, letters, text, etc. Proactive disclosure and FOIA requests. So we're going to discuss proactive disclosure a little bit generally, and then how you would see it in the context of procurement, as well as FOIA requests. So DC FOIA proactive disclosure. DC law requires agencies to make certain categories of records public without a FOIA request. And these are records that must be available to the public without the need of FOIA requests, and they include administrative manuals, regulations, organizational charts, awarded contracts or contract expenditures, budgets, policies, etc. So these are not a complete list, but it's an example of the types of documents that must be proactively disclosed. And you can consult DC Official Code 2-536 to see more of such type of documents. The public can access and search certain procurement information without filing a FOIA request using the OCP Contracts and Procurement Transparency Portal. As I noted earlier, awarded contracts valued at $100,000 or more are required to be available, and they are available on the Transparency Portal. Additionally, solicitations and opportunities, regulations, manuals, budgets and organizational charts, purchase orders, and purchase card transactions. And then I have also included a link to OCP's Open Government and FOIA page, where they've linked to a number of these things that are mentioned here. With regards to FOIA requests, this is information that I'm sure most of you all already know. 1 DCMR Section 400 contains the rules and procedures to be followed by all agencies, offices, and departments of the District of Columbia, and all persons requesting records pursuant to FOIA. These regulations can be accessed online. I've included the link there. Any person or entity has the right to inspect and at their discretion to copy any public record of a public body, except as expressly provided by the FOIA exceptions. DC Official Code 2-532A. Sorry, I got ahead of myself. Okay. And FOIA requests, of course, may be filed on the DC FOIA portal, and they may also be made by email, mail, phone, or fax, except in the case of the Office of the Attorney General, which must, I believe, be submitted in writing directly to OAG. So who handles procurement-related FOIA requests? So for procurement documents, you want to make sure that the request is being directed to the right agency. So the Office of Contracting and Procurement, also known as OCP, which I've mentioned several times, processes FOIA requests for most, but not all district agencies. In general, if an agency receives a FOIA request for some of the types of documents that we've been discussing, such as solicitations, contracts, modifications to contracts, bid or proposal scoring, or evaluation documents, then they should refer the requester directly to OCP. However, agencies with independent contracting authorities, such as the Department of General Services, District of Columbia Public Schools, and WMATA, process their own requests. And in these instances, FOIA requests for contract and procurement records should be submitted directly to these agencies. And I should also note that I've just listed these ones as examples, but this is not an exhaustive list of the agencies that have independent contracting authority. So that would be something that you would need to know about your agency if your agency has independent contracting authority and you subsequently receive requests for contract or procurement related documents, then you, as the FOIA officer at that agency, would be responsible for handling those requests. However, if you are a FOIA officer at an agency where OCP handles all of that, then you would want to refer the requester directly to OCP. Next, we're going to discuss exemptions and then a little bit about redactions as they relate to procurement. So the key exemptions that are relevant to procurement are the following three. This doesn't mean that other exemptions can't be related to them, but these are some of the most common ones that come up in the procurement context. So the first probably comes as no surprise. It's trade secrets and commercial or financial information. And that's DC Official Code 2-5341. Second is the personal privacy exemption, and that's 2-5342. And then another frequent flyer in this space is the interagency and intra-agency memos, 2-5344. So we're going to start with the trade secret exemption, which is the most common. Trade secrets and commercial or financial information obtained from outside the government, to the extent that disclosure would result in substantial harm to the competitive position of the person from whom the information was obtained. And so the purpose of this exemption is that it protects competitive interest. It often applies to vendor pricing, methodologies, or proprietary systems, and it requires a case-by-case analysis. And you would also, in doing that analysis, want to consider whether the information is publicly available. So to kind of illustrate this, I have included a recent MULC appeal that dealt with this issue. So in August of 2025, an individual submitted a DC FOIA request to the Department of Housing and Community Development, seeking records related to compliance monitoring of several properties. DHCD responded in October of that year and provided the requester with redacted documents and explained that the electronic documents have been redacted because portions of the information contained therein are subject to the trade secrets and commercial or financial information exemption. There were two other exemptions that were claimed in this case: the personal privacy exemption and the deliberative process privilege. However, the requester didn't challenge any of the personal privacy exemption material. And then separately, DHCD had acknowledged that it may have misapplied the deliberative process privilege. So when the appeal came before the MULC, the only issue that was still at issue was the use of the trade secrets exemption. So in their appeal to the Mayor's Office of Legal Counsel, more commonly known as the MULC, the requester maintained that DHCD had an obligation to provide any reasonably severable portion of the exempt records, and they noted that the agency had previously disclosed similar documents, which they argued resulted in a waiver of any privilege. DHCD maintained that it had properly applied the privilege and that there was no evidence that it had failed to provide any reasonably segregable portion of the records. And in its findings, the MULC noted that Exemption 1 protects information that, 1, is a trade secret or commercial or financial information, 2, was obtained from outside the government, and 3, would result in substantial harm to the competitive position of the person from whom the information was obtained. So that is, of course, the language from 2-534A1. And the MULC noted that the DC Circuit has defined a trade secret for the purposes of the federal FOIA as a secret that's as a secret, a commercially valuable plan, formula, process, or device that is used for the making, preparing, compounding, or processing of trade commodities, and that can be said to be the end product of either innovation or substantial effort. And that language comes from the case Public Citizen Research Group versus the FDA. Malk stated that DHCD had utilized Exemption 1 to redact information that was received from a housing provider, including the total number of units held, the market rate of these units, the number of vacant and occupied units, the unit/number of bedrooms, the maximum rent, the subsidy received, the rent charge, and the rent charged at acquisition. And so, in explaining why it had withheld this information, DHCD stated that the real estate market is a very complex and highly competitive industry. Developers seek every opportunity to capitalize on emerging opportunities. Applicants have a reasonable expectation when submitting their financial information that it will not be released to the public. And DHCD argued that it should not be compelled to disclose financial data of applicants and expose them to unnecessary risks and harm. Okay, and the MOLC found that because the requested information was obtained from outside the government, the party from which it was obtained faces actual competition, and the disclosure of the withheld portion of the documents would result in a competitive disadvantage, i.e. an injury. And so the MOLC agreed that DHCD may withhold the information that it had redacted under Exemption 1. MOLC further found that DHCD had released all non-exempt content from the responsive records that were identified, and thus the requester's assertion that they had failed to produce the reasonably segregable portions of the record was inapplicable. And then lastly, the MOLC found that the provision of records in another situation does not compel a similar result in this situation. And that was addressing the requester's kind of assertion that because similar information had previously been released by DHCD, that that constituted kind of, I guess, a waiver for that type of information. However, the MOLC disagreed. And they stated that unless otherwise provided by law, the release of records under DC FOIA is discretionary and can and should be made, notwithstanding the applicability of an exemption, if the public interest will not be harmed by its release. They noted that the public nature of information does not necessitate the subsequent release of related documents. And here they cited to the case Reporters Committee for Freedom of the Press, as well as Long v. the United States DOJ, and included a quotation from a finding in Long. The fact that some of the personal information contained in the records already has been made public in some form does not eliminate the privacy interest in avoiding further disclosure by the government. And so the takeaway then is, just because something has previously been released doesn't automatically make it releasable in a future situation. Okay, and then for an additional example of the application of Exemption 1, as well as a thorough discussion of best practices for the application of DC FOIA exemptions, I would direct you to the training that my colleague Joan Lelma gave about 2 weeks ago as the lead training in this series, what agencies get wrong specific to DC FOIA exemptions. And I provided a link to that training in case you weren't able to attend it when it was first given. So here's just a scenario regarding trade secrets. So let's say you received a request that was for all vendor proposals submitted for contract XYZ. In that situation, the agency action would be to release the confidential portions, which might include cover pages or general corporate information, and then to review and possibly redact any proprietary methods, pricing formulas, and unique technologies. Next, we're going to discuss personal privacy. So DC Official Code 2-5342, information of a personal nature where the public disclosure thereof would constitute a clearly unwarranted invasion of personal privacy. And I would note, personal privacy is one that most FOIA officers have to consider in any context. So, it's not surprising that it also shows up in the contracts and procurement context. But some specific things that you would want to be aware in a contract and procurement setting overlap with general personal privacy concerns, such as personal email addresses or phone numbers, any personal identifying information. This might look like vendor point of contact personal data, and you would only want to redact that information which is exempt. So just because there's personal information contained in a document, if the majority of the rest of the document can be released, then you would need to do so. You need to redact any of the personal information and then release what could be released. And in doing this, there's always the personal privacy balancing test. So when determining whether the exemption for personal privacy would apply to the requested records, both DC FOIA and the federal FOIA apply the standards set forth in Department of Justice v. Reporters Committee for Freedom of the Press, which requires that the government balance the individual's privacy interests against the public interest in disclosure. And so as a FOIA officer, you must perform the balancing test under this exemption. The individual's privacy interest in the material at issue must be balanced against the public's interest in disclosing it. And this public interest must serve the core purpose of shedding light on an agency's performance of its statutory duties. And then I've included the site to the case down there. And so in the procurement context, like you might think of what we were just discussing, if it's, personal email or personal phone numbers, but the requester is really just looking for like the terms of the contract or something of that nature, then obviously the individual's personal information, their interest in their personal privacy would outweigh any public interest in that context. Here's a scenario for personal privacy. Let's say you get a request for all emails between contracting staff and vendor B. And the agency's action would be to review and possibly release emails, but to redact personal phone numbers, private email addresses, and unrelated personal attachments. And then I've just noted that, although this scenario specifically addresses personal privacy, you would, of course, consider all applicable exemptions. So, for instance, if the requested emails discuss or contain a trade secret, you would not release those portions. And next is interagency/intra-agency communications from DC Official Code 2-5344. Interagency or intra-agency memorandums or letters, including memorandums or letters generated or received by the staff or members of the council, which would not be available by law to a party other than a public body in litigation with the public body. And so this protects draft versions of documents, internal deliberations, and any pre-decisional communications. So for instance, if an agency was communicating about, multiple vendors and they were having communications, with each other to help them decide which vendor would be best. Those are the kinds of communications that this exemption would cover. So examples in procurement might include draft scoring sheets, internal emails discussing vendor strengths or weaknesses, and preliminary award recommendations. All right, the light in my office is going out for a moment. Excuse me. All right, sorry about that. Okay, so a scenario for agency communications, you might receive a request for all evaluation notes for contract 123. So the agency action would be to review and possibly release final evaluation documents, if factual, and then review and possibly redact subjective commentary or draft analysis under 2-534A4. Next, we have a couple of additional scenarios. So for instance, a scenario in which you're comparing multiple vendor bids, what could potentially be released might be the total bid amount, unless it contains something like a proprietary breakdown, vendor qualifications, general descriptions of proposed services, and then what might potentially be redacted might be price breakdowns, proprietary software descriptions, or other trade secrets. It's a scenario for contract modifications. So generally releasable are contract changes in scope, updated pricing, new deliverables. Potentially exempt portions would be any vendor proprietary information or the personal privacy elements that we've discussed. Okay. And then in a scenario for communications between an agency and vendors, what would potentially be releasable be formal communications, scheduling emails, clarifying questions. But you should note that this does not mean that these types of communications cannot contain personal privacy or other exempt information. So obviously, while those would all be potentially releasable, you would have to, review the contents to make sure that there was no other exempt information. Right? And then potentially exempt draft negotiation notes, internal strategy memos, and vendor proprietary disclosures. And lastly, we have a scenario for post-award documents. So potentially releasable would be contracts, amendments, any final evaluations, and invoices. And then potentially exempt portions would be, again, sensitive personal or proprietary information. And although I didn't include that disclaimer, with all of these, anything that's potentially releasable, you would still need to review the documents to make sure that they don't contain anything else that would be exempt. For instance, I mentioned earlier in the training that contracts above $100,000 are proactively disclosed by OCP, but nonetheless, any like PII contained in that contract or any other exempt information would have to be redacted, even though the contract itself will be made available to the public. That's the conclusion of the main part of this training. If you've got any questions, I would welcome them at this time. Sorry if I was flying through that a little bit quickly. So if my colleagues could let me know if there's any questions in the chat.
There are no questions in the chat.
Okay. Let's see. And I'll give you a moment in case some of you are thinking if you have any questions about what has been discussed today. And while you're thinking on that, I would draw your attention to the upcoming DC FOIA trainings that will wrap up our summer FOIA training series. So next week, Chief Counsel Louis Neal will be presenting DC FOIA appeals, analysis, and insights. And although I've not put it here on the slide, I also want to make sure that you all know that in the afternoon or evening of July 30th, if you are available and would like to join the staff of OOG and other FOIA officers, we will be having a happy hour at, I believe the restaurant is Blackfin. And by now, I think you should have gotten email with kind of the details on that, along with the announcement for Chief Counsel Neal's presentation next week. So any of you who are free and would like to join us, we would love to see you. And then getting back to the training. So on August 6th.
Brandon?
Yes.
Just wanted to clarify, on the 30th, which is next Thursday, we'll have a special training time, which is at 3 o'clock, not 2 o'clock, for that one instance. And we're offering both in-person training here at 1030 15th Street, as well as the hybrid option, virtual or online.
Right. And thank you for those details, Anthony. And then on August 6th, Director Allen will be presenting electronic records, text messages, and AI, modern FOIA challenges. And then on August 13th, we will wrap up the series as we have for the last couple of years with a presentation on preparing a civil case and defensive litigation, which will be delivered by Brendan Heath and Adam Daniel, who are Assistant Attorneys General with the Civil Litigation Division of OAG. And that will be followed with a question and answer that's going to be moderated by Director Allen. And as always, I have included all of our contact information. If you have any questions, you can always email us at opengovoffice@dc.gov. We all have access to and we'll see any emails that go there. Additionally, this is the main number here. And should you need to get in contact with any of us directly, all of our email addresses are listed here on this page.
And Brandon, you now do have one question in the chat from
Yes.
Our colleague at DCPS, who asks, would final score sheets be deliberative?
So I believe if it is final, that it would not be deliberative. If they were score sheets that were being used in the process of determining, for instance, which vendor to go with, those would be deliberative. But I believe once it's final, that the deliberative exemption would no longer apply. But I would also throw that to my colleagues in case they have any more insight on that.
Yes, Brandon, I agree. However, I would recommend, and this is the way that the courts usually go, even though it's a final score sheet, to evaluate, to do your analysis and see whether there are information that should be redacted. But generally, the entire score sheet is not withheld because that's a final document. But because of the nature of the document, parts of it may be exempt.
That's a great points, and thank you for that, Joan. There are no further questions, I will stick around for a few more minutes in case anyone has any questions or wants to stick them in the chat. But if not, thank you for attending today. And we look forward to seeing you at our next training. And for those of you that can make it, we look forward to seeing you next week at Blackfin. Thank you.